The next matter to come before us this morning is in re ATPCDTCQ and HQ. Good morning.
Good morning, Your Honors.
The state is waived oral argument. We have read the briefs and we're ready to proceed when you are.
Thank you. May it please the court, I'm Denise Ferguson. I'm representing Kelly Quattrochi, and I find myself in an interesting position in this case. I was before this panel, well, not this exact panel, last September arguing this case. And Your Honor, Judge Hensel, you were on that panel. You actually wrote the decision. And what I'm asking you to do today is to reaffirm that decision. This court, back in September, reversed and remanded the permanent custody in that the trial court committed reversible error by finding permanent custody and not granting legal custody to my client. That was the finding back in September, according to the appellate case decision. Okay, and that appellate case decision was 28220, the decision in that case. When this went back to the trial court, I filed a motion in the trial court to either return the children immediately to my client or dismiss the case because we were beyond the 2 years. The county, Summit County Children's Services, filed a motion for a nunc-pro-tunc for the judge to rewrite her decision. The judge wrote a new decision stating, with all due respect, how she found that your decision here was wrong and inaccurate. And that there was enough evidence to support permanent custody. This court ruled on the merits of clear and convincing evidence, whether it was reversible error to grant permanent custody when my client wanted legal custody of her children back. That is the argument that this trial, or this court reversed the trial court on.
You would agree, though, it isn't a nunc-pro-tunc. It is a new decision, right?
It's a new decision, but it was in response to a request for a nunc-pro-tunc.
Right.
And that is not what a nunc-pro-tunc is for.
Sure, but it's not like the court just added things or changed things from the old decision, but actually issued a whole new opinion. Now, whether it's right or not, that's another issue.
Well, she did issue a new decision that included elements from the old decision, and then it counterpointed the decision in the appellate case as to why there was enough evidence.
Sure.
Could it be that the decision the last time on appeal focused on the fact that the findings were in a time made relevant to a time period that wasn't applicable under the statute, and then it didn't have a whole lot to do with what evidence was presented and what wasn't presented?
Well, this court actually found that in the evidence presented that mother had a good relationship with the children. She had made strides on the case plan. She acted appropriately. She had new housing.
And the trial court also made those statements in the trial court's first and now the second order, correct? That mother had positive
In passing, yes.
aspects of the case.
Yes. But if this court were to allow the trial court to rewrite a decision, until the trial court got it right, how long does that go on? The trial court, in rewriting this decision, is taking a second bite at the apple and making findings of fact. And they did it far after the 2 years on this case was up. Because you can only get 2 6-month extensions according to statute.
Well, you can't get another extension because you can't do temporary custody beyond the first year, 2 6-month extensions. But rewriting the decision, it looks to me like, the way the decision was written back last year was that the trial court's explanations was finding under E1 focused solely on facts that predated replacement, why the children were removed from the home. remedied in the period after they're removed from the home. That's how I'm reading that. Is that wrong with that?
That is what the trial court is stating, yes, that this, here's the reasons why after the children were removed.
Because the reasons they were removed in the first place weren't remedied.
That is what this one is stating, yes. However, that goes to my second argument, that I still do not believe that there is clear and convincing evidence for a myriad of reasons. And I know that that is somewhat a repeat of my first argument, the first time around, regarding whether or not there was enough evidence. I know the trial court, in my second argument, my third argument do dovetail into one another. Because part of the sufficiency and whether or not there's clear and convincing evidence is the guardian ad litem recommendations. That those are taken into consideration. She gave weight to those. And we had a guardian in this case that was unsure of what his role actually was. He was objecting to his own counsel every time his own counsel opened her mouth. He would object, and he actually got into an argument at one point saying, this counsel does not represent me. I am the guardian ad litem. I have a right to represent myself. And he was shut down by the trial court for that. He also stated that he never went out to see. Part of the reason the children were removed was the condition of the home. Mother moved after the children were removed. The guardian ad litem never went to see that new home at all. Said he wasn't going to see it. He had no reason to see it. The children were never going back there. They were located in a better neighborhood when they lived in Green rather than in Akron, and that they should remain in Green because that was in their best interest to live in a more prestigious neighborhood. The guardian ad litem also referred to one of the children as a postal worker waiting to happen. He was very derogatory towards these children. He called one of them a dandy.
The children did not also have appointed counsel, did they, at any point in the proceedings?
No, they did not.
And they indicated they want to return home. That's my understanding.
That is my understanding as well. And I know, to my understanding, they may still want to return home. I do not believe they had appointed counsel because the only people that I saw listed were counsel for father and the guardian ad litem counsel. I may be wrong about them not having appointed counsel, so I don't want to misspeak. But
No one advocated for them at the hearing, right?
Not that I recall.
I mean, the GAL was there, but I'm saying as to their desire to return home.
No one that I recall advocated for them. There was a lot of issues with the fact that mother had moved, she was no longer with father, and a lot of what was found by the judge the second time around was father's unemployed, father has legal issues, father is doing this, that, and the other. One of the fathers at least. The other father was deceased. And mother was not with father. Mother had moved into another home with her father, her own father, so the grandfather. And it was deemed an appropriate house by CSB, and all the testimony said it was appropriate. Mother was also in counseling. One of the issues was she hadn't gotten enough counseling. Well, she signed releases, she was getting counseling. CSB wasn't satisfied with that provider, even though she'd been with that provider for several months, if not years. They never made a referral to a new counselor until December 2015, which was after they filed for permanent custody. They then held that against mother, that she hadn't gone to Guidestone more than a few times before the permanent custody trial, even though she had been seeing another doctor for her mental health issues, and the referral wasn't made until December. They also, CSB also testified she doesn't know how to deal with AT. AT allegedly perpetrated sexually upon his siblings while in CSB custody. This court has found that you can't hold a parent responsible for issues that arise while in CSB custody. And this wasn't a week after CSB got custody, temporary custody. This was several months along after the children were removed that AT perpetrated upon his brother. And they never got him help when this was brought to light in June until the following December, after permanent custody was filed. And yet, during the testimony, they tried to use his issues against mother. It was okay that this child in their care, who was a minor, did not receive the help he needed until December, but mother, who was seeing a doctor all this time, didn't change doctors until December when the referral was made. The referral that came from the agency. The standard is clear and convincing evidence. It is not probable cause. I do believe there is an issue with meeting that burden of clear and convincing when it is looked at to what mother was doing. The records from her psychiatrist or from her doctor were given to the agency. They had it and they presented them. They decided at a late date that it wasn't appropriate enough. And that was CSB's call. Up until then, they had no issue with the fact that she was seeing this doctor. I would ask that this court reverse this permanent custody due to the lack of clear and convincing evidence and due to the fact that the GAL did not do his job. And I'm not talking Rule 48. I know I've said this before to this panel or to this court. I'm not talking Rule 48. I'm talking statutorily under 2151. A GAL is required to do an investigation. And while the trial court found that he completed a thorough and comprehensive investigation, and he is familiar with the home environment while the children were in the custody of the parents, he also witnessed the difference in the boys' lives since coming into care. The guardian ad litem believes it is in the best interest of the children to be placed in the permanent custody of Summit County Children's Services. Problem is, he hadn't been out to the home in 17 months. There were several months in which he never went to the home to see what changes were made.
He also recommended that the children go to the permanent custody agency, which was against the children's wishes, and counsel should have been appointed for the children.
I concur with that, yes. But I am just asking on behalf of mother that this case be reversed and that she be given the chance to parent her children. Are there any other questions?
Seeing none, thank you.